to say the second and third row of cars, Mr. Rosenbaum, correct?
Correct.
This red is Mr. Zeminski, green Mrs.,
Yes.
white Kyle.
Yes.
And Richie McGinnis is to the left of the television screen, correct?
To the right.
In pink.
To the right of the television screen.
To the right. Sorry. Roll it, please. Stop. As Kyle, the white circle, comes to the Duramax, this individual, Mr. Rosenbaum, begins to come out of his hiding place.
Yes, he comes around the vehicle at that time.
And he's masked,
Yes.
and he comes around, roll. Stop. Blue, again, Mr. Rosenbaum, correct?
Correct.
And now you begin with the chase, Mr. Rosenbaum of Kyle Rittenhouse, correct?
Correct.
Stop, not yet. Correct me if I'm wrong, but this looks like a classic ambush.
I'm going to object as to the calling for the defendant's interpretation of things. The jury can make their own decision as to what the...
Sustained.
Okay. Mr. Rosenbaum is in hiding as my client arrives, correct?
It appears so, yes.
My client gets...
You have described your impressions of what Mr. Rosenbaum was meaning to do or intending to do in his final physical acts towards the defendant. Would you agree with me that you've given us your impressions of that?
Yes.
At any point, did you hear Mr. Rosenbaum say anything about the defendant's gun?
I did not know.
He never said, I want your gun, I'm going to take your gun, give me your gun, I'm going to steal your gun, anything along those lines.
I didn't hear anything like that, no.
And you've already established that after the shooting, Mr. Rosenbaum never says a word, correct?
Correct.
You don't know, as you sit here today, what Mr. Rosenbaum was thinking, do you?
You mean at the time of the shooting?
Yes. Or at any point in his life. I mean, you have no idea what Mr. Rosenbaum was ever thinking at any point in his life. You have never been inside his head. You never met him before. You don't know.
I've never exchanged words with him, if that's what your question is.
So your interpretation of what he was trying to do or what he was intending to do or anything along those lines is complete guesswork, isn't it?
Well, he said, fuck you, and then he reached for the weapon.
When you describe these interactions with the people walking past, was the defendant present for any of that?
He had one exchange that I saw.
Who was that with?
Just some random person in the crowd screamed, "Fuck you."
At the defendant?
Yes.
How did the defendant react to that?
He said, "I love you too, ma'am."
Now, we've seen video here, and you may have seen video as well, that Anthony Huber ran towards Kyle Rittenhouse while Kyle Rittenhouse was armed. Were you surprised when you heard about that? Were you surprised by his actions? Had you ever seen Anthony Huber run towards danger?
Yes.
Sustained. As to which ground?
Both.
It's character traits for peacefulness is what they're getting into. I have 2 criminal complaints, one of which the defendant held a knife to his brother's throat. He put a knife to his brother's ear. He called him. He said he would gut him like a.
He said what?
Mr. Huber told his brother that if he didn't start cleaning a room in their house, he was going to gut him like a pig. Mr. Huber's brother noticed a knife in Mr. Huber's right hand that looked like a butcher knife, 6 inches long with a green handle. Mr. Huber later on in the same incident threw a chair and some clothes across the room, threatening to kill his brother if he didn't clean. Mr. Huber then sat down with the knife in his hand and watched them while his brother and Mr. Huber made his grandmother pick things up as well. And Mr. Huber told his brother that if he stopped cleaning, he would kill him. Mr. Huber's brother then turned around and Mr. Huber put a knife to his brother's stomach, saying he was going to gut him like a pig. Mr. Huber's brother bent down to try to protect himself. Mr. Huber then grabbed his brother by the neck, dug his nails in, and choked him for approximately 10 seconds. He then put a knife to his brother's left ear. His brother felt the blade and believed his ear was cut. And then as he left, he told the people in the house, "I'm going to burn the house down with all you fuckers in it." That's what Mr. Huber had said in that instance.
But this sounds like something that he'll be allowed to go into.
Understand?
What do you want to do?
I will not submit the evidence.
You what?
I will withdraw that question and not submit the evidence.
You'll withdraw that question and?
I'm not going to elicit that testimony.
Okay.
So, Mr. Grosskreutz, on the morning of the 26th of August, do you remember telling the officer who interviewed you, sometime during the incident, my Gen 4 Glock 27 that has a belt clip attached fell off my waist? Remember that?
I don't recall saying that, no.
And if I could, toward the end of that large paragraph, you'd agree it says, sometime during the incident, my Gen 4 Glock 27 that had a belt clip attached fell off my waist, correct?
Correct.
Okay. That's a lie, right?
I wouldn't say that's a lie, no.
You didn't take the Glock out of your back here and run with it?
I did.
So it didn't fall off your waist. It was in your hand.
That's correct.
So you would say that's not a lie?
No, I would say it isn't.
Okay, and you told that to multiple officers. Isn't that true?
I don't know.
Same exhibit, sir. The next sentence. I told multiple officers that I dropped my firearm, right?
Correct.
Okay. Now, you didn't drop your firearm. You were chasing Mr. Rittenhouse with your gun, right? Yes? You were chasing him with your gun? Yes?
No.
You didn't chase him down Sheridan Road, pulling your gun, chasing after him. That's a lie. You're saying that didn't happen.
I'm not saying that it didn't happen, but I wasn't chasing the defendant.
You were running after him?
No.
No. Okay. Did you ever get charged for not telling the truth to the police about dropping your gun?
No.
Did you ever tell the police in here on this statement that you actually had a firearm in your hand and pointed it at the defendant?
No, I did not.
You never told them you had a gun at all in terms of as you had an interaction with Mr. Rittenhouse. True?
That is correct.
So I'm going to show you what has been marked as exhibit number 62. This is a notice of claim. Is that right?
That is correct.
Okay. Filed on your behalf by your lawyer, right?
That is correct, yes.
Making a notice or telling, among others, the city and county of Kenosha that you would like $10 million. True?
That is correct.
Did you read this?
I did.
So are you aware in this document, you never mentioned that you actually possessed a firearm? You know that?
That is correct.
You left that part out, right?
That is correct.
Judge, I would move 62.
Is there objection?
No.
See,
You then had, shortly thereafter, I want to say in October, I'm going to show you what is Exhibit 63. You have now filed a lawsuit in federal court. Is that right?
That is correct.
Did you read that?
Yes, I did.
In that document, you again failed to mention that you possessed a firearm. Is that right?
That is correct.
So you, in these documents that you are filing with courts, you are leaving out the fact that you had possessed a firearm when you were shot, right?
That is correct.
Okay. And this is, so to be fair, this is your testimony today, and how this case turns out has an impact on your ability to try to collect your $10 million, right?
That is correct.
So if he's convicted, if Mr. Rittenhouse is convicted, your chance of getting $10 million is better, right?
I'm not entirely sure how that plays out.
Haven't had any conversations with your lawyer about
well,
that?
you're not going to ask him about conversations with his lawyer.
Okay, fair enough. You were asked, were you armed with a firearm, and you said that you were, right?
When
Mr. Binger said, what do you bring? And you said, keys, wallet, whatever else, and a gun, right?
I did say that, yeah.
Kind of standard operating procedure for you out in the summer of 2020?
Not just the summer of 2020.
Oh, so you had carried your firearm at times previous to that?
That is correct.
And you're doing that for personal protection, correct?
Correct.
And you're carrying it concealed, are you not?
That is correct.
It's unlawful for you to carry it concealed. Is that not true?
Unlawful?
Yeah, you can't carry a concealed weapon without a CCW permit, right?
That is correct, yes.
You have to open carry. You have to have, been talking about people with their guns out. You have to carry it with it out if you don't have a CCW permit, right?
That is correct.
And you didn't have a CCW permit, did you?
I did have a CCW permit.
It wasn't valid, correct?
After the fact, yes, I found out that it was not valid.
So have you been charged for unlawfully carrying a firearm in this case?
No, I have not.
Now, your original statement then to the police was, I tried telling the guy to stop hitting him with the skateboard. The guy on the ground then turned over, racked the weapon, and pointed his gun at me and shot me, right?
That is correct, yes.
You omitted the fact that you ran up on him and had a Glock pistol in your hand, right? You left that out.
Correct.
Would you think in a case where you are shot that providing the police information that you were possessing a firearm at the time would be relevant?
I think that's fair, yes.
Okay. So, Mr. Grosskreutz, I'm going to show you what has been marked as Exhibit 67. That's a photo of you, yes?
Yes.
Okay. That's Mr. Rittenhouse?
Correct.
Okay. Now, you'd agree your firearm is pointed at Mr. Rittenhouse, correct?
Yes.
Okay. And once your firearm is pointed at Mr. Rittenhouse, that's when he fires his gun. Yes?
No.
Sir, look, I don't want to... Does this look like right now your arm is being shot?
That looks like my bicep being vaporized, yes.
Okay. And it's being vaporized as you're pointing your gun directly at him. Yes?
Yes.
Okay, so when you were standing 3 to 5 feet from him with your arms up in the air, he never fired, right?
Correct.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct.
You had
When you asked the defendant if he'd shot anyone, he lied to you, didn't he?
Yes, he did.
And even though you've been asked questions about what he said at various times or things like that, did he make threats to anything like that, to people, anything like that? You construed his actions as threatening, didn't you?
Based off of witnessing the first two shots with Jump Kick Man, the third shot that killed Anthony Huber, yes.
Thank you.
I have one question. He didn't lie to you, right? When you had contact with him, he didn't lie to you, did he?
Yes, he did.
How did he lie to you?
After having asked him who was shot, and then him saying, I'm going to the police, which we know after the fact, and then saying, I didn't do anything.
So it's your testimony today that you heard. Now, to be fair, your first interview that you signed, you said that he told you, I'm working with the police, right?
I'm going to object. This is beyond the scope of the direct.
Right?
That is what I thought I heard in the moment, yes.
Okay, so you weren't telling the correct statement, correct?
Can you...
Yeah. You said that Mr. Rittenhouse lied to you.
Yes.
Your initial statement to the police was, he told me I'm working with the police. You know that's not true.
After the fact, yes.
Okay. So what is on tape is he said, I'm going to the police, right?
Yes.
You're not saying that's not true.
No, I'm not.
Nothing else.
Describe your meeting with Mr. Binger and Mr. Kraus in their office.
Object to relevance.
Answer it?
Please.
I don't know the date off the top of my head, but I was called down to the district attorney's office. I met with Mr. Binger and I don't remember his name.
The individual who's
In the blue. And I was called into a room, sat at a table, handed my police statement, got to read over my police statement, and then I was asked if I would like to add anything to the police statement, and I said I would not. Mr. Binger pulled out a cell phone and showed me a video and also a photo, which was actually one photo that I brought today, and asked me if I knew who a gentleman was in that photo, and I said I did not. And he asked me to, he said, this is Joshua Zeminski. Mr. Binger also has a case with him, and I am subpoenaed for that case also. And he says, well, that's who that is. He put the phone down, he picked the phone back up and says, who is this? And I confusingly said, like, Joshua Zeminski, and he's like, would you like to add that to your statement? And I just felt I didn't want to change my statement.
okay. And as a result, what did you do?
I hired an attorney.
And that's Mr. Rose.
Yes.
I have nothing further.
Mr. De Bruin, you said there was a lot of tension in the room when you met with me and Mr. Binger and Ms. Beasy.
Yes.
Is it fair to say that you were very nervous?
Yeah, absolutely.
And we did have you read over your statement, right?
Correct.
And we asked if you knew anything beyond that statement.
Correct.
We didn't ask you to change it.
Yes, you did.
You have a bias in this case, don't you? You don't want Mr. Rittenhouse to be found guilty or not guilty?
Oh, wait a minute. You don't want him to be found guilty or not guilty?
You don't have an interest or a bias in which way this trial comes out?
I don't know. I'm
Did
a
you-
photographer, photojournalist. That's what I do. I take photos.
Did you go and give an interview to a gossip site that is biased against the district attorney?
I don't know what his site represents.
So you actually went to the media, or someone who claims to be media, to talk about this meeting with the prosecutors?
First of all, he came to me. I didn't go to him. Let's make that clear. All these photos, I was threatened numerous times. So I was uneasy with people still standing outside the police department, walking in, knowing I have to walk out with these people out here.
So you gave the statement 17 days after the shooting. Is that accurate?
Yeah.
And you're still saying that property was being destroyed and there were protests
There was
7
no-
days later? Let me finish my question, please. 17 days later?
There, nothing to the extent of the week of the shooting, nothing to that extent, but there was no window in the police station.
So the fact there was no window made it so you could not give an accurate statement?
I'm not saying that. I
You
said
just did.
it gave me anxiety.
Yeah, it's not the way it's-
Yeah, so make sure you
He
say
didn't
what
say
I'm
he
saying.
He didn't-
Oh, okay.
He
So
did not say he didn't make an accurate statement. That was your words.
Not
you said,
mine.
you said things were left out of your statement.
And Rosenbaum started shouting back at us that he's gonna, pardon me, Judge, for saying this and everybody else, but he was gonna kill us motherfuckers, motherfucking niggers, and cut our hearts out.
That gentleman on the screen there said that.
Yes, multiple times.
Okay, thanks. Go ahead.
So you're telling us that the reason that you wanted Dominic to buy you an AR-15 as opposed to a pistol is the only reason was because you felt you couldn't lawfully possess a pistol?
Correct.
You didn't pick out the AR-15 for any other reason?
I thought it looked cool, but no.
You didn't pick it out because you wanted to go hunting with it, did you?
No.
You didn't pick it out because you were going to use it to protect your house, correct?
Correct.
You picked it out because it looked cool.
I thought it looked cool. Guess
It-
that's the reason, yes.
It resembled the types of weapons that are used in first-person shooter video games, correct?
I don't really play first-person shooter video games. I have, but I believe there's a variety of guns, including shotguns, pistols. There's guns in video games that resemble all guns.
Isn't it true when you would hang out with Dominic Black, you'd play Call of Duty and other first-person shooter video games?
Sometimes.
And those are games in which you use weapons like AR-15s to pretty much shoot anybody who comes at you, correct?
It's a video game where two players are playing together. I don't really understand the meaning of your question, to be honest.
Isn't one of the things people do in these video games try and kill everyone else with your guns?
Yeah, in the video game, it's just a video game. It's not real life.
And you picked out that gun because Dominic had it, correct?
Yeah.
You could have, if you wanted to, chosen from any number of guns that were for sale. Fair enough?
That were at that store, there weren't many, but yes.
I'm sure the store in Ladysmith isn't the only store that sells guns, correct?
You can ask questions.
That was a question.
No, it was a statement.
Isn't it correct, Mr. Rittenhouse, that there are other places to purchase guns besides that one store in Ladysmith, Wisconsin?
I believe so, but that's where we're at, so that's where we got the gun.
And you, if you wanted to, could have given Dominic Black money to purchase a gun at other locations. Fair?
Didn't cross my mind, but now that you say it, yeah.
Why did you pick or want Dominic Black to buy for you an AR-15 as opposed to a pistol or a shotgun or some other type of rifle?
I cannot legally possess or carry a pistol because I'm not 18 in Wisconsin. I believe it's 18 in Wisconsin for a pistol. But with the rifle, I knew I could possess that rifle. I knew I couldn't buy it, but I knew I could take it to the shooting range or possess it. And with shotguns, they didn't have any shotguns in stock. That was my original plan, to get a shotgun for trap shooting. But there weren't any at that Ladysmith store, and I didn't want to go to Walmart and buy one.
So your understanding at that time was that Wisconsin law prohibited you as a 17-year-old from possessing a pistol, but you could have an AR-15?
Yes.
What was that understanding based on?
The understanding was based on when we would go up north. It was me, Dominic, and my sister, and we were allowed to carry the rifles around, and the officers over there said it was fine.
I'm going to move to strike as hearsay as to what officers would have told
You
you.
asked the question on what the sort of.
Since August 25th, 2020, this is the first time that you have told your story.
Object to this.
Sustained.
Since August 25th, 2020, you've had the benefit of watching countless videos of your actions that night, correct?
I've seen certain videos, not all of them. I've seen the majority of them actually here during the trial.
You've also had the opportunity to read articles. People have written interviews, things like that, about what happened that night, correct?
I do my best to avoid what people write on the internet. A majority of it, it's not true.
You have also sat here through 8 days of trial, correct?
Yes.
And you've had the opportunity to watch all of the videos that have been
Yes.
played in this trial?
Yes.
Sir, if you could please let me finish my question before answering. And I will do my best to let you finish your answer before I go on to the next question. Fair?
Yes.
You have also had the opportunity to listen to the testimony of all 30-some witnesses that have testified in this trial so far, correct?
Yes.
And after all of that, now you are telling us your side of the story, correct?
Correct.
I'm going to ask you folks to go in the library for just a second. Please don't talk about the case.
He's commenting on my client's right to remain silent.
No, Your Honor. I am making the point that after hearing everything in the case, now he's tailoring his story to what has already been introduced.
The problem is, this is a grave constitutional violation for you to talk about the defendant's silence. And that is, and you're right. You're right on the borderline, and you may be over, but it better stop.
Understood.
This is, I can't think of the case, the initial case on it, but it's this is not permitted. All right, ask the jury to come in, please.
You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to stop someone from smashing the windows of an unoccupied parked car, correct?
I don't think you could use deadly force for that.
You'd agree with me that you can't use deadly force to stop someone from lighting a metal dumpster on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone from tipping over a porta potty, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone from lighting a flatbed trailer on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone who is about to start an unoccupied car on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone from lighting some traffic cones in the middle of the street on fire, correct?
Correct.
So you understand that there's a difference between using deadly force to protect yourself and using it to protect property, correct?
Yes.
And you'd agree with me that you're not allowed to use deadly force to protect property, correct?
Yes.
But yet you have previously indicated that you wished you had your AR-15 to protect someone's property, correct?
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the case. Mr. Richards?
Your Honor, Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this
and he's asking the questions. I ask the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an experienced attorney, and he knows better.
Mr. Binger?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that, and the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move to reconsider.
That was their motion.
We have not filed any motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed, even if you're correct in your assumption that you know more than I did at the time. You should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this case, testimony in this case, that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record, if I could, without being interrupted, if that's okay. He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property.
He didn't have the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is.
May I respond to what you just said, Your Honor? I'd like to respond to what you just said. I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay. I believe that there is a central part of this case that Mr. Rosenbaum is making threats that he has no ability to carry out. So, to your point, Your Honor, you're arguing that this August 10th incident, one aspect of why you don't believe it's relevant is the defendant didn't have the gun with him. This case is about someone who didn't have a weapon, and yet the jury is being told because of those threats, that means the defendant has to defend himself. So, with all due respect, Your Honor, mere verbal threats have already been shown to this jury and used as a basis for someone's subsequent actions. I am attempting with the defendant to use his mere verbal threat on August 10th, 15 days prior, that he's going to shoot shoplifters with his AR-15 to impeach the defendant in a murder trial. I would ask the court's forbearance to do that. I apologize, Your Honor. You're right. I probably should have brought this to your attention earlier. I may have misunderstood your ruling because I thought your ruling was if the evidence in this case made that more relevant, you would admit it or at least consider it an admittance. I believe, based on the evidence that we've heard, and more specifically exactly what the defendant said earlier about admitting pointing a gun at someone who was merely jumping or sitting on a car, that the door is open now to this testimony. And I continue to believe that his state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion. You were strongly inclined against it. I understand that. But now we're in the middle of trial, and there's been a lot of evidence that's come in that I think makes this relevant. So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call
his statements too, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, the court has seen no reason to change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's prior reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop. And he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein. Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense. That's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
But that was where I was coming from, was there's been a change in the testimony of the defendant today that I think makes that evidence. It's admissible and much more relevant than it already was, and I thought it was already relevant. And the court is... I do want to be clear
so
also...
I'm just here on the sidelines, just...
well, you...
Yeah, I had made a ruling that the evidence wasn't coming in, and you decided that it was.
If I could just respond to that briefly, Your Honor, I was about to say, I did not interpret your ruling as an absolute... We've had 3 state motions in limine. There was one in which we asked the court to introduce evidence that the defendant was at Pudgy's bar with Proud Boys, and you were clear, that is not coming in. There was...
You know, don't get into other subjects. Come on, what you're telling me, you're an experienced trial attorney, and you're telling me that when the judge says, I'm excluding this, you just to take it upon yourself to put it in because you think that you've found a way around it? Come on.
If I may finish, Your Honor, I was about to say that your ruling on our 3 motions and other acts motions was there were some gradations there. That you were clear that some things were absolutely out, and then you left the door open on other things. So I saw that distinction, and I thought to myself, clearly I know this is out, but you left the door open on other things. So I didn't interpret your ruling as this is absolutely never coming in, and I have practiced before you, Your Honor. I have filed other acts motions before you. Your practice oftentimes is to reserve ruling on those until you see the evidence. And I think you even said something to that effect at our motion.
I undoubtedly did.
So I thought, this is my good faith explanation to you, and if you want to yell at me, you can. My good faith feeling this morning after watching that testimony was you had left the door open a little bit, now we had something new, and I was going to probe it.
I don't believe you. There better not be another incident. I'll take the motion under advisement. And you can respond. When you say that you were acting in good faith, I don't believe that, okay? Let's proceed. Everybody in good faith.
I'll try. So what we're doing here, what you've done is you've taken a still photograph, right?
Yes.
You've blown it up and added pixels to that photograph.
That is correct.
Okay. Those pixels have to contain or do contain information, right?
That is correct.
Some of that information is color, correct?
That is correct.
Okay, so if the best example I would give you is if you take a picture of my chest, my shirt, and you blow it up, you're going to be adding pixels around my shirt and my tie, correct?
Yes, that is correct.
Okay, so the question is this. In terms of the accuracy of that enlarged image, you don't know whether those pixels are black for my tie or white for my shirt, right?
I cannot speak to the algorithm that's being used and how it's interpreting that.
And that, to be fair, that could distort or not make an accurate picture of what we're seeing, right?
It's possible.
Right. So the images, and when we're looking at smaller images that are blown up, adding color that's not actually there can make the photograph not accurate, right?
But all the steps that were taken are repeatable.
So what does that have to do with the fact that you don't know what the colors are added? You don't know the colors that are added, so how do you know that's accurate?
I do not know to the algorithm and how it's using it.
So when we're doing that on small images, like a marker in my hand or something like that, and you want to see what this is from a far distance away, it might be adding color that's not actually there, right?
It may be.
So the image that we're asking people to look at might not actually be an accurate representation of the original image. True?
It's possible.
He is enlarging, he wants to enlarge the image. And he's inserting some pixels in there. And so he gives it a command to insert the pixels. And he doesn't know what color they're going to come out. Is that it? Is that it, sir?
I would say, Your Honor, it's as to how that algorithm interpolates those pixels and where it places them goes outside the scope of my knowledge.
Well, what do you, I mean no disrespect, what do you know?
What I do know is that the process that I use to expand or enlarge this image and the interpolation method that was used. Anything beyond that within my software, with the software I use, I do not have any additional information.
And competing programs might insert different colors.
It's possible.
And you wouldn't have any way of knowing.
I do not have any way to know if those different interpolation methods would issue different colors to different pixels.
The defendant will rise and face the jury and hearken to its verdicts.
State of Wisconsin versus Kyle Rittenhouse. As to the first count of the information, Joseph Rosenbaum. We, the jury, find the defendant Kyle H. Rittenhouse not guilty. As to the second count of the information, Richard McGinnis. We, the jury, find the defendant Kyle H. Rittenhouse not guilty. As to the third count of the information, unknown male. We, the jury, find the defendant Kyle H. Rittenhouse not guilty. As to the fourth count of the information, Anthony Huber, we, the jury, find the defendant Kyle H. Rittenhouse not guilty. As to the fifth count of the information, Gage Grosskreutz, we, the jury, find the defendant Kyle H. Rittenhouse not guilty.
Members of the jury, are these your unanimous verdicts? Is there anyone who does not agree with the verdicts as read? Would you wish the jury polled?
No.
Okay. Okay, folks, your job is done, and we started just about 3 weeks ago. And I told you it could last 2 weeks and 2 days. This is 2 weeks. This is 3 weeks. Mr. Richards?
Your Honor, I judgment on the verdicts.
Any word from the state?
The jury has represented our community in this trial and has spoken.
All right, the motion of the defendant is granted. The charges against the defendant on all counts are dismissed with prejudice, and he is released from the obligation of his bond. Anything else?
No.
Thank you. Good day.